Welcome to today's webinar. We're going to get started in just a moment. We'll start right on time at 12 o'clock. So we just have a few more moments while a few more people get signed in. This is great. I see everyone signing in right now. So like I said, we will get started in just a moment. Okay, we are going to get started on today's webinar. So good afternoon, everyone. Officially, it is now afternoon. I'm Hunter Boucher, Director of Operations at LandlordBC. And thank you for participating in today's webinar, Rent in the Time of COVID-19. I want to start by thanking our guest presenters today. So we have Grant Haddock, who's a lawyer at Haddock Company, as well as Oscar Miklos, also a lawyer at Haddock Company. And then I, myself, Hunter Boucher, will be providing some information on the BC Temporary Rental Supplement. This webinar is made possible by our sponsor FortisBC. So thank you so much to FortisBC for providing us with the ability to do this. So again, thank you so much for that. Keeping up to date in these ever-changing times is a difficult task. So please watch our e-news and our website. I know many of you already are, which is how you found out about this. But if you aren't already, check our website. Make sure you're registered for our e-news. It's as simple as going to our website, landlordbc.ca, scrolling to the bottom, and signing up at the bottom of the page. So without anything further, I'm going to go right into the BC Temporary Rental Supplement. And there's a lot of information available on this supplement that is new, created specifically in response to COVID-19. It is a supplement that is meant to help tenants cover a portion of their rent. So how much does it help? Well, for individuals, it is up to $300 per month, while households with a dependent are eligible up to $500 a month. The supplement is currently available for up to 3 months. Those specifically are April, May, and June. So some important things to know about this supplement. The first is that tenants who are living in illegal suites are still eligible for this this supplement. So it is not a criteria that it has to be a legal conforming suite, which is really, really important to be aware of, because they need tenants who are living in illegal suites, which there are countless legal suites. That's a bigger issue, not something we're going to discuss today by any means, but they need support as well. And landlords in those situations should be assured that BC Housing, which is administering, that is the organization that administers the supplement, will not be sharing that information with other governing bodies. So just because a tenant applies for this does not mean that it's going to go to your local municipality or provincial or federal governments in any way saying that this is an illegal suite. That is really important to be aware of that. So how does this application work? the way it works in general is that the application is initiated by a tenant. So tenants make the application by going to the BC Housing website. And if you go to the BC Housing website, you'll see a lot of information, again, on this supplement. They can go through, make sure that they're eligible. They can self-check to make sure that they are going to be eligible for this, and they can make the application. Landlords complete the process, though, but you as a landlord cannot initiate the process. Again, the process is initiated by tenants. It's also important that you make sure that tenants have what they need to make this application in advance. So when they go to make this application, they're going to need certain paperwork. And we all know that tenants have the proclivity to occasionally lose their tenancy agreements or other paperwork. So it's a good idea to make sure that you have one on hand should your tenant require one, even offer one. Say, you know, I've scanned a copy of your agreement, here it is, just so you have that on hand when you go to make the application. It can really help in that process so they don't have to dig around and try to find their agreement, which they've lost. So again, just really, really important that you make sure that you try to work with the tenant as much as possible to help them get through that and get to the point where they can make that application successfully. Now, a big question that comes up is, what about roommates? We have two roommates. Is that one household? Is that one person? Does only one person apply for it? Can both? So when it comes to roommates, each roommate on their own can apply for the BC temporary rental supplement. They have to meet the criteria individually. So that's something that they would have to do on their own, but each one can apply on their own, which means it's possible that if two roommates apply and they don't have dependents, each would get $300 towards their rent, which clearly is a significant way towards going towards the rent. And this is meant to be in addition to the other government supports that are available to individuals who are impacted by COVID-19. And we'll get to kind of the last question that people have on this. And we know that there are going to be other questions. And in fact, I see that the questions are coming in right now. We will get to questions at the end of the webinar in general. We'll have a Q&A session with myself, Grant, and Oscar. But the last question I want to address right now is, what about people who perhaps are not Canadian citizens or permanent residents? And certainly in British Columbia, we have a lot of people who live in our province who are not Canadian citizens or permanent residents. They're here as students, international students. They might be here on a working visa, a temporary foreign worker. There's a variety of reasons why someone who is not a citizen would be living in one of your rental units. And most people who are here from out of country are not going to be owning a home, they're going to be renting a home. So they are tenants and they are eligible for this as well. For students, again, so long as they're not living in a educational facility run housing, they are eligible for this as well. And for anyone else, so long as they are legally allowed to work in the country, so they have that working visa permit, they are eligible for this supplement as well. So it is meant to assist all tenants of British Columbia, regardless of their status of whether or not they're a citizen, a permanent resident, or just here on a working visa or as an international student, which is really important because the impact to landlords is the same either way. So that support is there either way. So that is it for the BC temporary rental supplement. I know that there's a lot more questions that people have, but we want to get into the presentation from Oscar and Grant. So I'm going to invite Oscar onto the line now and stop sharing my screen. Just be one moment while we switch over. Thank you for patience on that. Okay, Oscar, you can go ahead and take over.
Excellent. Can everybody hear me? I hope Hunter, can you hear me?
Yeah, we can hear you.
Perfect. So I'm just going to set up the screen share here. 1 second. We did this successfully yesterday, so I hope it works right now. We'll put it in. Oh, there we go. Okay, so again, Hunter, can you see my presentation now?
We can see your slides, definitely.
Perfect. Okay. Well, so welcome everybody. First of all, Hunter, thank you very much for that warm, almost a movie star welcome there with the slides and everything. I feel like it was like a movie intro there. So that's awesome. And welcome, obviously, everybody else. There's a number of different people who are joining us. I saw the count just going up progressively as Hunter was speaking. So hopefully now by this point, everybody who wants to have logged on is logged on. Of course, we have a number of LandlordBC members. I assume that that's the bulk of today's attendees are members of the what I call LandlordBC family. And I really mean it's a family because, you know, when you do go out to these events that you guys host, you just see this, you know, same people over and over again. And it's really nice to see familiar faces over the years. And because of the relationship that our firm has had with LandlordBC, both Grant and I have gotten to know a number of members and, you know, just again, really just a family there. I do also want to acknowledge the Housing Guide readers so this past week I was able to send out a blast to my own website, housingguide.ca, and the readers there. Hopefully some of them are joining us as well for this webinar. And then, of course, the general public. So I understand that LandlordBC was gracious enough to open this webinar to everybody, all landlords across British Columbia. So even if you are not a member of LandlordBC, then you still have access to this webinar. And I think that's a great thing, particularly in time well, during these tricky times where there's such a need for information. So I did want to acknowledge everybody's presence there. And I do want to just, by way of a short introduction, introduce our firm. So my name is Oscar Miklos. Grant Haddock, who's the founder of our firm, is going to be presenting a little later on. He's going to be going through the rent deferral agreement that we've actually drafted. And our firm is well positioned to solve any sort of housing dispute. So the way I put it, you put enough people under one roof and there's bound to be some problems. And so, you know, our firm is set out with a mission to resolve these issues. And, you know, a large part of what we do, a large part of our practice is residential tenancy law. My own practice is split about 50-50 down the line between strata property matters and residential tenancy matters. So that just by way of an introduction. And again, you know, I will highlight that regardless of where you're, you know, joining us from, which part of British Columbia you're in, and there might even be some landlords who are just, you know, joining from all over the world. But the beauty of technology is that this allows us to assist you regardless of where you are geographically. So I think that's a great advantage with technology. So without further ado, let's get into the presentation itself, which is rent in the time of COVID-19. So we are obviously living in a very different reality. You know, I think webinars are a great thing to have anyways, and you know, make things accessible. But you know, often these type of presentations would be happening at LandlordBC events in person. And you know, the reality is that right now we're not able to do any sort of in-person presentations or meetings of groups of larger than 50 people. So on that point, you know, I will highlight that the province has evoked a state of emergency. It's legislation that is designed to effectively provide the government the ability to have effective responses and enact certain powers that normally they wouldn't be able to do so. So, you know, this is really the exception to the rule rather than the rule. You know, a lot has changed, needless to say. I think everybody's impacted in one way, shape, or form. As I have mentioned, gatherings of more than 49 people, you know, not permitted. And of course, we have the shutdown of certain essential businesses. Explains partly why I kind of starting to look like Chewbacca, as I haven't had a haircut for a while. Effectively, the public is just limited in terms of their interactions, and and is having to stay home generally to avoid person-to-person transmission of the virus. So that's the reality that we're living in, and of course, a lot of different things have flowed from this situation, which is to say that among the many things that have been impacted is our residential tenancies. And so, I think back to about December of 2017, if I'm not mistaken, if my memory serves me correct, that's when the government, the provincial government, got rid of fixed-term tenancies with vacate clauses, or should I say, for most part, fundamentally changed the law in that. And I remember at the time, my phone was blowing up with rental property managers who would be calling in to ask Oscar, what the hell's going on? And since the March 30th, 2020 order of the provincial government, in response to the COVID-19 crisis or pandemic, my phone has been very active again. And a lot of people are wondering, what exactly it is that they're allowed to do now that the ground rules have changed. And the reality is that the government has, for I would say very valid reasons, curtailed a lot of the the rights of landlords in respect to whether it's entry into the rental unit. Of course, we're going to be talking about the issue of payment of rent. That's the biggest one, and the ability or inability of landlords to evict tenants in certain instances. So all that to say, the authority, the government authority to take this type of action, all flow from the Emergency Program Act and the order that was given by the government on March 30th of 2020. And so if you read actually the wording of this order, not horribly complicated to read, but ultimately most of it deals with residential tenancies, at least the order that is referenced on the slide there. So I'm not going to go into an exhaustive list of everything that is in that order, but again, as it pertains to today's topic, I think the biggest thing that you can take away from it is that most evictions have been temporarily halted, if you will, but not all evictions have, right? So in short, if I was to summarize that order, you can no longer evict the tenant by way of issuing a notice to end tenancy. So as most landlords will know, that is the traditional way of ending a tenancy, is by issuing the notice to end tenancy. Of course, these notices take a variety of forms. There's the 1-month form, there is the 2-month notice, and as of a couple of years ago, there's the 4-month notice. It used to be also 2-month notice. It used to be only 1 and 2 months, but now you have 4-month notices as well. And all of those notices essentially are moot, which is to say that if you issue a notice, you can still, nobody's going to stop you from issuing that notice, but effectively those notices have no effect right now, and the tenants can simply ignore them. Now, I will just backtrack and just make sure that people understand the effects of the March 30th order. They're only in effect until the government lifts what's called the state of emergency, right? So I think that's very important to understand that this is not something where the law has fundamentally changed for good. This is a temporary measure that's being enacted by the government in accordance with, like I said, the authority that gives them the ability to do that. Essentially, your rights to. So let's talk about situations where you may need to evict a tenant. Well, there are some circumstances where you can still evict a tenant, but these are severely curtailed. So you can apply still for an early order to end a tenancy if, and I'm just gonna, there we go. So the grounds for evicting a tenant right now, you could apply to the residential tenancy branch for an early order to end a tenancy if it would be unreasonable or unfair for the building occupants or landlord to wait for the state of emergency to end. So that is first and foremost, it's actually a prerequisite, which is to say that everything else that you see on that slide, all the other grounds of eviction that are listed there, they're coupled right now with this precondition, which is to say you have to make sure that you're able to convince the residential tenancy branch that it would be unreasonable under the circumstances to wait for the state of emergency to end. Okay, that's an additional requirement that we didn't have before with these early orders, the Section 56 orders. But of course, you have the specific grounds that are listed on this slide, which is to say, if a tenant has significantly interfered with it or unreasonably disturbed another occupant or the landlord of the residential property, right? So significant interference, I always tell my clients, you're usually looking at a repeat pattern of problematic behavior, right? So one event or one issue likely, unless it's particularly egregious, likely is not going to be enough, not going to be sufficient for an end to the tenancy. But if you do have, if you show a problem of repeat problem of problematic behavior, should I say, repeat pattern of problematic behavior, then you are going to increase your odds of success of getting a successful eviction. You have a tenant who may have seriously jeopardized the health or safety or lawful right or interest of the landlord or another occupant. You can have a tenant who has put the landlord's property at significant risk. You have tenants who may be engaging in illegal activity. So illegal activity, typically, again, you know, with respect to, you know, the high threshold that these evictions are, you're probably talking about criminal activities here. So, you know, for example, a breach of a strata corporation's bylaws, you know, even though it's, you know, illegal, it's off or not on par with what is required, but it's not going to constitute an illegal activity in respect to this grounds to end tenancy. So an illegal activity that has or is likely to cause damage to the landlord's property, has adversely affected or is likely to adversely affect the quiet enjoyment, security, safety, or physical well-being of another occupant of the residential property, or has jeopardized or is likely to jeopardize the lawful right or interest of another occupant or the landlord. And finally, you have if the tenant has caused extraordinary damage to the residential property. Again, extraordinary damage is a very high threshold to meet. You're not going to be in a situation where you're evicting a tenant just for a few scratches on the countertop. You know, I know it's kind of silly, but I've literally had a client who told me that they wanted to do exactly that. And I had to tell them, look, I don't think you're going to be successful because at the end of the day, that does not qualify as extraordinary damage. So if you apply, or you can also apply for an order if the unit is ordered shut down, as it may become uninhabitable. So for example, if you have a frustrated tenancy, that's another ground. And that probably is about it. Now, let's go back to situations where you cannot evict, which is to say, anything that would normally require a notice under the Act, you're now looking at an inability to evict, which is to say, or an inability to issue a legally effective notice. So the biggest one, and that is really the topic of today, is unpaid rent, right? So what happens when your tenant just says, you know, because of this pandemic and because of the layoff or you know, job losses that have been occurring, we just can't pay rent. Well, you know, there are solutions there still, but ultimately one of your recourses, your primary recourse, which is eviction, is no longer available. Okay, at least not for now. Again, repeat late payments of rent. So, you know, if you have situations where let's say your tenant is paying rent, but, you know, throughout this COVID-19 pandemic, they are just late in paying rent. Again, normally it could be a 1 month notice. Now you're not allowed to do that. You know, your 1 month notice is not going to have an illegal effect. And certainly another situation where you may give a 2 month notice is if you are, let's say, a landlord who, you know, let's say it's a month-to-month tenancy, and you want to give your tenant a 2 month notice for your personal occupancy of the property, of the rental property or the rental unit. You know, that again is problematic. You can't do that. And you know, about a couple of weeks ago, I had a presentation with about 300 odd realtors there. And these realtors were all kind of freaking out because, well, what happens in situations where you have a contract of purchase and sale where the buyer and the seller have agreed that the seller is going to give notice on behalf of the buyer for to the tenant in order to have the tenant vacate. And you know, those are very complex situations because you actually have two, not one, but two agreements, legal agreements that you're going to consider, which is the, of course, the tenancy agreement and whether you're allowed to do that under the tenancy agreement. And then also you have the contract of purchase and sale. So what I would suggest is if by any chance, if anybody is facing that type of situation and you're not able to legally meet the requirements that you've signed or that you've obligated yourself to under a contract of purchase and sale, best to talk to your conveyancing lawyer. They may be able to come up with some solutions, but it's certainly a problem that you know that is occurring as a result of these of this order here. It is now turning to the situation of, well, you know, well, what happens with rent, right? So at the end of the day, one thing to keep in mind, one very important thing to keep in mind, and something that you should remind your tenants of, is rent is still legally due. The debt still exists. If they don't pay their rent, you know, it's not, the order does not have the effect of forgiving non-payment of rent, right? The only caveat, or the only thing that you cannot do, is you can't issue a 10-day notice for non-payment of rent to the tenants right now. Okay. That being said, there are a number of different options, and so effectively, Grant is going to take you through the rent payment form, the rent deferral form in a second. But the other thing to consider is you still have the option to apply to the residential tenancy branch for a monetary order. So all that to say, you still have options. It's just that your primary recourse of evicting a tenant for non-payment of rent is currently not an option. So without further ado, I believe, I'm gonna pass the presentation now over to Grant, who is going to speak to you about the rent deferral agreement that our firm has come up with.
Am I seen and heard?
We can hear you and we can see your slides. You just need to put it to presenter view and put your webcam on.
Oh, my webcam's not on. Excuse me. All right. One sec here.
Fantastic. So just don't need to share your screen.
Sorry. Yeah. Scroll through the bit. All right, thanks. Hello, everyone. I'm Grant Haddock. I'm principal of Haddock Company. Oscar gave us a pretty good introduction here. What I'm going to do is go through what's called the short form rent payment agreement or rent deferral agreement. What we're looking at here is, basically a kinder, gentler way to make sure that your tenants are feeling good about the rent. So as Oscar says, rent is payable, and it's due on the 1st of the month. So why would you need to get into an agreement with your tenants on when they have to pay rent? Well, there's a lot of anxiety out there right now, and your tenants are probably feeling that anxiety, as are landlords. Everybody is. We feel as an industry, it's probably better to get into amicable agreements with the people who owe you money as to how that money is going to be paid, rather than have this hanging over their heads as to what might happen to them if they don't pay it, which is, in a lot of cases, it's going to be eviction. It's a better way and a better business model to make arrangements now with people who can't pay rent. And so that was the whole idea behind putting together the rent agreement or rent deferral agreement. So there is a long form, which I like, and I only like it because I'm a lawyer, and lawyers like long forms. And there is a short form, and the short form one is probably the more popular. Both long form and short form are available on LandlordBC and from LandlordBC. I'm going to do the short form today because it's adequate for its purposes. I prefer the long one, again, if I really want to make sure I've got an ironclad concrete contract. I like my my long form, but there is a fear that the long form will scare your tenants, and it might even scare landlords to look at it too. So maybe simplicity is better. If you've got more savvy tenants, or business savvy, maybe long form is okay to use. It really depends on your tenants, and you should take the temperature of your tenants to make sure that you're using the correct form. So let's launch into the short form. And so the first thing you want to do is identify the parties correctly.
Grant?
Yes.
So I'm going to interrupt you. You just need to change the view.
Oh, I'm sorry.
You have your screen share on, because it's not showing the slides. It's just showing your home PowerPoint. You can choose different view options there.
No, where's my view options then? If I push stop, oh, here we go. Is it a new share or?
No. So under the screen share.
Hold on, I gotta get out of this one then. Stop share, okay, screen share, yep.
Yeah, so just choose the one that has the actual, the slide that you're on.
Okay. And then push share?
Yes.
Okay. Does that work?
No, you're not sharing the slide. You're just.
Let's go to screen share, and then I have to go to is that, can you guys see that now?
If you can just go to presentation view.
And where do I find presentation view?
In your PowerPoint.
Oh, I see. Oops. Oh, how about if I just use this? Because I can do it this way. Does that work?
There you go.
Yeah, I'll use that. All right. There we go. Okay, let's get the identify parties correctly. So here's the very first page from the rent deferral agreement. We want to make sure that we're identifying our parties correctly. I have seen many, many instances, even on landlord and tenant agreements, where the parties aren't identified correctly. There's mistakes made as to who the tenant actually is, and often I see mistakes made as to who the landlord is. This is because I don't know, various reasons why that might be, but you want to make sure that the name of your tenant matches the name on the lease document. You want to make sure the landlord is the actual owner of the property, or if you've got a trust or a family trust or whatever it is, and sometimes you see the property manager's name on there as well. I'm not sure why that is. I mean, it seems to be industry. There's property managers often show up as the landlord as far as the RTB is concerned. If you're a property manager, you might be lumped in as one of the, also as somebody who is a landlord. So be careful about that. Make sure you've got the right names on there. We go to the preamble now of the agreement, and it's preamble is like the nice way of saying, well, here's how we're going to set this up. The preamble has got details of original tenancy agreement, and it's going to add the current monthly rent. So here's your preamble of the short form. And so what you're going to do is, at the first part, you want to make a base here. Your baseline is going to be, I have an agreement with my tenant, and here's what it is. You have to add the date of your tenancy agreement here, and then you have to describe what it is they're renting. Usually it's the physical civic address, like 123 Maple Street. Be careful if you've had internal moves in the same building, because I've seen some tenants agreements that have got unit 10, but for reasons I don't understand, they're in unit 23. Well, 5 years ago, they moved into a different unit. They just transferred units. So keep an eyeball on that too. And if there's a difference between your original tenancy agreement and what you're doing today, explain that in the whereas in the preamble here. You want to set out the current monthly rent, and that's important because you want the tenant to acknowledge what their current rent is and acknowledge their legal obligation to pay that rent. And then preamble C is the tenant has requested that the landlord defer rent. I mean, you're always going to hope that conversation happens. You're always going to hope that the tenants will come to you and say, look, we really want our rent deferred. Can you help us out? It's always troublesome when tenants don't even bother to speak with you and simply don't pay rent. So Article 1 of the short form agreement, this is where the tenant makes representations to you. And these are legal representations that you can rely upon. So, I've seen a couple of questions pop up in the chat room there about, well, what do I do if they are lying about it? Or what if they're not applying like they should? This is a section where the tenant is going to say, well, here's why I really need this. Not just because I quit my job and I don't want to go in. It's because something's happened, and it's COVID related. And so you've got a number of different options. The tenant's employment's been terminated. They can check that off. They've been laid off. Their hours have been significantly reduced, because that's happened to a lot of people. They're working, but don't have enough to pay rent. They might be self-employed, and their business income is significantly reduced. There's actually a lot of self-employed people out there who are falling through the cracks because they generate their own income. They have a lot of write-offs, so it never really appears that they made much in the first place. But that's the whole point of being self-employed. And now they're looking for help too, because whatever income they had is completely dried up. There's another part of it. Maybe someone, like some of your tenants, they rely upon someone to pay or assist in paying their rent. And the only, I think, often situation I run into is like the elderly who are on pension or have limited resources, who rely on a relative to pay their rent. And there could be another. So we've got an opening there just to, in case if there's another circumstance that they want to put in there and disclose. So Article 2 deals with how are you going to pay it back? And so you're going to set out what it is they're not paying back. What's the amount that they're going to defer for this month? And then you're going to decide, the two of you, how it's going to get paid back. I think the first option is the one that most tenants are going to choose. They're mostly going to go and say, I want to pay back like a certain amount every month until I'm done. I mean, that's how most payment plans work, even in commercial situations and nonprofit housing, even it works that way. They're going to be paying, $1,000 a month rent plus $200 extra to pay off the $1,000 they deferred the other month. So, that said, you could be looking at a very long horizon of people paying rent over a number of months if this carries on. And we know for sure it's probably going to be 3 months. You've got April, May, June, we'll probably have to deal with. July is sort of the light at the end of the tunnel. Perhaps things are going to get back to normal, but it's going to be a long time from normal for a lot of people. And we might have to be dealing with these kind of forms and these kind of agreements for a while longer. So, some money is better than no money, I always say. And so you have to make sure it works for you and it works for the tenant. And so the tenant says, well, I'll give you $10 a month for the next 100 years. That probably doesn't work for you. It works real well for the tenant, but doesn't work for you. The second option you might have is a deferred rent will be paid in full. That's going to be rare. And it's rare, but it's possible, because some people might be looking at a payout because they've been laid off and then they have to be terminated, because you can only lay people off for so many weeks and then it turns into termination. Or they might be getting a big chunk of back rent that might be coming. So they might want to choose that option, that I'll pay you in full. I'll pay the the $3,000 I owe you on August the 1st, 2020. This has got Article 3 of the short form. The provincial grant application deals with that. And so what it's saying is that the tenant, if they're eligible, are representing to you that they have or they will apply for the provincial government 500 grant or 300. That could be changed, because 500 is for the person with dependents, 300 is for the single person. So you'll have to do a bit of amending there, depending on who your tenant is. Currently, it's I put like a variation of the provincial government program, because who knows what's going to look like. Things are evolving so fast. But the point here is that when we wrote this, it was early days. It wasn't even available to apply. Now it is. You can probably change this to saying like the tenant, if eligible, has applied for the provincial government thing, rather than or will apply, because I would expect everybody who can apply has applied. Article 4 deals with a set-off, so it's only fair that any monies that the landlord receives, because you get those monies directly from the government, will be a credit towards the rent owed by the tenant. So if the tenant's agreed to pay you $1,000 over time, the $500 that you get from the government, if that's what the tenant is entitled to, you would use that to set off. So the debt now for the tenant is now $500, not $1,000. So ending the agreement, this is not Never Never Land. You want to make sure that you've got an exit from this in case things don't turn out as they were represented. The first is that if the landlord determines that the information the tenant provided was not true, because they could say, oh yeah, I lost my job. In fact, they didn't. And they just looking for a way to not pay you rent for a while. If you are able to find that out, or someone discloses it, or they, I don't know how, these things tend to pop up. You could end this agreement, and then all the rent is due. If the tenant fails to pay any portion of the deferred rent, you can end the agreement, and the whole amount becomes due. And then if either party, should the tenancy agreement be ended for any reason whatsoever, now, tenants can leave if they want. We all know that. We're not. It's not so easy for landlords to make them leave whenever they feel like it. But tenants can say, "Well, I'm done here." As long as you're past your 1 year tenancy, if that's what you have in place. But if once you're month to month, the tenants can say, "Oh, I'm going to leave and go now." And if they're in the middle of or at the beginning of their payment plan, well, you don't want them paying forever as they move to Toronto or something like that. You want the money now. So if the tenant decides they're going to go and end the relationship with you, then the money becomes due in full at that point. Article 6 deals with amendments to the agreement. The way the agreement is written, it's dealing with the month in question. So the agreement is written for what do we do with April rent? And then it's written for what do we do with May rent? So if you sign an agreement in April, you want to be able to amend that agreement to take into account, oh, well, gosh, now they can't pay May or they can't pay June. So you can make amendments to it. And that's easy enough to do. The payments will be extended or increased or whatever you need to do to deal with the tenant and what they're able to do. So that's very useful, because this deferral we know is at least 2 months now, probably 3, and perhaps more. So the back end of this, that's the agreement itself. There's one thing I might point out in the agreement is I've got some good wording in there about how you deliver notices in the days of COVID. I've got some better emailing abilities for delivering notices to tenants. Now it's not sort of guessing or wondering which email to send it to, or as the ministerial order says, the one that you generally use for the tenant, which I don't find that compelling as far as service matters go. I've put in the agreement, like, give me an email address so I can officially serve you with that. So the back end of this is, what do you do with a tenant who refuses to pay, period, or agree to a deferment agreement? These are the guys who just won't talk to you and just say, well, I don't have to pay. John Horgan says I don't, so I won't. Or you present them with a deferral agreement, they go, I don't like this, I'm not going to sign it. Well, what do you do? Well, you have to deal with it sooner or later, but how do you protect yourself in these circumstances? I suppose the first part is you wait and see what happens, but you want to evidence this somehow. And as lawyers, we know, like, it's remarkably difficult to prove a negative. Like, where do you get the evidence to prove something didn't happen? It didn't happen, right? I didn't get rent. So, but you want to create an evidence trail of that. Like, what are the conversations you're having with the tenant? If you're able to put it in writing and emails, those are better, because of course those are producible. You can print them off, and then that's exhibit 1. But if you can, you got to create a paper trail. And if the tenant says or blows you off or whatever and says, I'm not going to pay, you write an email. I confirm you told me today that you're not going to pay me rent. This will be brought to the attention of the arbitrator, or whatever you need to do. Those are letters that I send. But you can copy that approach and use that to build your case. You could, as Oscar said earlier, head off and get a monetary order. Right now, nothing prevents you from doing that. And you might even get it faster because things are hopeful. You think it'd be a bit slowed down at the RTB right now. They won't have the massive amounts of applications they often do. If you want to send a message and you want to get your monetary order right now, nothing prevents you from doing that. And then when things are lifted and evictions are allowed, well, you've got your monetary order in hands. You have to also deal and think about collection issues once the emergency is over. You have to think about whether your clients are even good for it. Are you able to garnish them? Can you, where are you going to find the money? If they flee at the end of all this, are you just throwing good money after bad, chasing them, trying to find out where they are? So those are just collection issues. That's more of a business decision. There's plenty of outfits out there, including my law firm, to go and get the money. Of course, we're the most expensive option out there, so you'll want to be looking at other debt collection vehicles other than law firms. But we have a battery of tools to go after people. It's just that lawyers, the amount of money you'll spend on us will quickly equal and perhaps be greater than what you might lose on rent, unless you're dealing with a high rent situation, like if someone is paying like $3,000 or $4,000 a month. That suddenly gets worth it to get after lawyers. Rent increases, just the one last thing, since we're talking mostly about rent. We had a nice reasonable rent increase this year. Well, now we can't use it if you haven't already used it earlier. So the rent was set to increase while if the rent was set to increase while this ministerial order is in place, the rent increase will not take effect. There's an exception. Additional rent increase for additional occupants is permitted. So it has to be in your tenancy agreement. So if you've gotten an agreement that we can charge you an extra $100 for every extra occupant you have, you can do that. But that's the only exception there is right now. And there's no rent increases or no rent increases do not become effective while this ministerial order is in place. So that's us. If you need to talk to us, and I will hand it back over to our Master of Ceremonies, Hunter. If Hunter's still there.
Yes, I am. I'm just starting the screen share right now. Thank you very much. Okay. Thank you, both Oscar and Grant, for that valuable information. It was great. We're going to get into the Q&A session. So just a reminder, there's a few ways that you can communicate with us throughout this webinar. There's a chat box as well as a Q&A box. So if you make sure, so we can only have to check one spot, you can make sure that you're putting your questions in the Q&A box. Just want to remind you again that this webinar was made possible by our sponsor, FortisBC. So thank you, FortisBC, and thank you to you. You come to view these webinars to educate yourselves, to be informed, and make sure that you're running your rental housing business in the best way possible, especially during these very challenging times. So visit landlordbc.ca for more information. Make sure you sign up for our newsletter if you're not already getting it. Again, thank you all for attending today's webinar. We're going to get now into the Q&A session. So I know that quite a few questions have come in, so thank you so much for sending in these questions. So the first question that I have that came in here is really for I guess for you, Grant. You talked about this deferral agreement, this payment deferral agreement. So the question, when putting in the amount of rent, should that be the total amount of rent or the amount of rent less the government subsidy?
It should be the total amount of rent, because unless you've already No, it would be it's the total amount of rent, because the agreement goes on to say that if there is a government subsidy, or if the government subsidy comes in, it acts as a set-off. So in all circumstances, put the total amount of rent.
Okay. And do you record that that government subsidy has come in on the agreement, or is that done elsewhere?
You could if you wanted. It starts to get messy, but it's a matter of evidence again. The landlord will say, well, I've got the rent. I think both landlord and tenant are notified that the grant arrives with the landlord. You could, I mean, if you have the money in hand, then nothing prevents you from adding to that particular paragraph that the money has come and it is a set off, and I've received $300 or $500.
Fantastic. Thank you for that clarification. So a question, I believe, for you, Oscar, regarding monetary orders. Can you explain briefly what a monetary order is and where you obtain it from?
Okay, well, thank you, Hunter. So ultimately, a monetary order is a piece of paper from the residential tenancy branch that says, you know, X party owes Y party some money. Now, you know, I always tell my clients that, you know, monetary orders, and this goes back to what Grant was saying, actually, you do have to consider the solvency of the the person who, you know, who you have the order against, which is to say, you know, it's so to answer your question, the first part of your question, you're going to get the monetary order after having applied to the residential tenancy branch for a dispute resolution hearing, right? So it's a telephone hearing usually that they'll have, and you know, ultimately the arbitrator will decide whether the money's owing or not. And if if you do get a decision from the residential tenancy branch, and with rent payments, it's probably the closest thing you can get to a black and white issue. You know, there are very narrow exceptions where that allow the tenant to withhold payment of rent or set off some part of the rent. But most of the times the tenants will not be falling into those exceptions. And so, you know, it's like I said, it's almost a closest thing you can get to a black and white issue at the RTV. And if you do go through the process, you do get the piece of paper that says that the tenant shall pay the landlord X amount. Then you have to consider, well, how are you going to enforce that monetary order? And that sometimes is the much trickier bit, which is to say that if the tenant has no money, you know, then and we spoke about this yesterday, Hunter. So you're going to go through, as far as enforcement, you're going to go through the small claims court, file your monetary order with the small claims court. That's the venue that has the ability to enforce the order. But you know, can you then, for example, garnish the $2,000 a month that the government is giving people nowadays? And the answer is no. It's a social assistance that's being provided by the government, and so effectively you're not going to be able to get your hands on any part of that as a landlord who's trying to enforce their monetary orders. So you do have to consider your options in terms of enforcement. You know, in very rare instances, you're going to have tenants who may have property within British Columbia. I say really rare because I've probably come across it like once or twice in my practice. And other times you might be looking at garnishing wages from employers. But again, if nobody's working right now, you might be SOL, put it that way.
Okay, so another question regarding the payment of rent and security deposits. Is it possible mid-tenancy to use a security deposit to cover some of the rent? And what are your recommendations on that?
Grant, you want to take that?
I was going to say you should take that.
Oh, okay. Well, so the answer is if you're mid-tenancy, I wouldn't suggest you do that. The reality is that you should be keeping your security deposit until the end of the tenancy, because that security deposit, the main purpose, the function of that security deposit is to make sure that when the tenant leaves, that you do have everything in place in terms of that the property's left reasonably clean and undamaged as required by the Residential Tenancy Act. So, applying that security deposit right now for the payment of rent, while the tenancy is still in place, probably not a good idea. With respect to, let's say let's say you get to a point where, they lift the state of emergency, the tenant is owing so much rent, and now all of a sudden the tenant realizes, well, now they can be evicted, or now you can all of a sudden issue a 10-day notice. Well, once the tenancy's ended, right, then you can do the accounting, and if there's rent that is owing, and you do get the tenant's written consent, and I do say written consent. Grant has mentioned earlier how important it is to document everything in order to prevent further disputes, or in order to prevent you from shooting yourself in the foot when going to the RTB. So really, you want to document this. You want to get the tenant's written consent to say, it is agreed between the parties that, as a result of, even if, let's say, the tenant has left their rental unit clean, right, and undamaged, but because they're owing X amount of rent, you can say, okay, well, consent of the tenant, written consent is received for retaining the security deposit in part or in full to offset the unpaid rent.
Okay. So definitely great. So I have two questions that have come in that I'm going to take, because they're about the BC Temporary Rental Supplement. The first is someone who has received the funds from April and May, and will likely get this in June as well. The question is will this be extended to July? And the answer is we do not know yet. It's a little too early to tell what type of government supports will be coming in the future months. Certainly, LandlordBC has been very vocal about the need for an increase in supports that tenants receive during this very difficult time. And you can see quite a few examples of us speaking out, our CEO, David Hutniak, in the media quite frequently over the last several weeks. The next question that we have on this same topic, so I'll take this and kind of get this out of the way, is again around this supplement, and can students apply for the rent subsidy? And the answer is generally yes. The supplement is meant to help all British Columbians who are renting in this province. So students are able to apply. Again, they have to meet the criteria just as anyone else would. And the criteria generally looks at whether or not their means of income has been reduced or completely removed, the ratio of rent to income, and their income over the last year. So there's a variety of things they need to meet to be eligible for this criteria. And if you go to the LandlordBC website, you'll see information on this as well about the subsidy. And we'll send you out more information in our thank you email follow-up that'll come after this webinar. And just a note as well that the slides from today's presentation and the webinar itself, which is being recorded, will be available on our website as well. So, so again, students are eligible for this as well. So let's just go and see if we have another question for the two of you. Okay, so kind of a speculative question, and I know the answer. When do we expect that the state of emergency will be lifted and things will go back to normal?
Oh gosh, well, that is speculation. I said July. That's what I'm guessing.
Yeah, I think that at this point, none of us are really aware when things will be returning to normal, especially within this industry. Certainly, there have been announcements yesterday from our Premier Horgan, who announced a plan to resume things to what is being called a new normal. Our industry was not addressed specifically in this, as many industries were not. So certainly there'll be some type of transitionary plan that'll come into place.
I tell my clients I'm a lawyer, not a fortune teller, and if I was a fortune teller, my hourly rate would probably be a lot higher, actually.
Okay, so just one moment here. So a question regarding about getting written consent to do things such as deduct from the security deposit. Would an email reply in the affirmative by the tenant constitute written consent to make this deduction from the security deposit if you were to go that route, which I know we've said, and LandlordBC echoes, likely don't want to do, but in some cases perhaps there might be reason to do so.
Yeah, so for any sort of consent issues like that, and even for I know we're getting a little braver these days, and Dr. Bonnie is going to allow us to be a little closer to each other. But in early days, did you really want to go to your tenant's suite and sign the rent deferral agreement in their place? Well, no, and perhaps you weren't allowed to. But so how would you get it done? Well, you can certainly do what's called signing in counterpart by email, which is that, you know, you could email the deferral agreement to the tenant. They could sign it. They could either PDF it or turn it into a PDF or take a picture of it on their iPhone and send it back to you. And then you would sign it and you'd have a couple copies, and that would be perfectly legal. There's some goofy arguments out there as to, well, maybe someone fake my signature or something like that. Those don't likely fly if you're using an email that you generally use. So the ministerial order also came up with this service issue, which was you're allowed to serve someone on an email that you normally converse with someone about tenancy issues on, which is very vague, really. It's not an email that someone's given you to officially allow you to send things to, which the Strata Property Act allows. But here's a ministerial order saying, okay, well, we're going to allow this to happen because it's COVID-19. We have a pandemic. So to answer Hunter's question directly, like if someone sends you an email back and say, I consent to something you asked them about, and it's the email you converse on, I think that's something you can rely on and evidence you could use if the person tried to dispute it later.
The other thing I would add, just to what Grant was saying, is if you're feeling, very technologically competent, then you could actually try out a e-signature software platform such as HelloSign or DocuSign. I know realtors, I myself in our firm, we use Signority. Reason why we do that is because it's based in Canada. And ultimately, it's a fantastic tool once you do get an opportunity to start using that. I think what's going to end up happening is a lot of these technologies that people are all maybe discovering right now just because of COVID-19, in the future might become standard practice. For example, even signing a tenancy agreement with a tenant, you just send it by way of e-signature and then they get it signed, and then you have a beautiful legible copy in digital format. So just another suggestion there.
Yeah, well, I mean, we're definitely moving in a very rapid way now to a more digital rental environment, that's for sure. Things have definitely changed quite a bit. Thank you both for your insight. Thank you to our attendees today for your thoughtful questions and your attention. Again, thank you to our sponsors who made this webinar possible, FortisBC. And have a wonderful day. Make sure you watch out for our news for upcoming webinars.
Thank you, Hunter.
Thanks.